Section 7. Unit 3, Loan Assumptions and Modifications. Introduction and Objectives. Lesson 1, New Property Owner, Same Loan. Lesson 2, Modifying a Finance Instrument. Loan Modification. A loan modification is an agreement between the borrower and the lender that creates permanent new payment terms. The intent is to make the loan more affordable for the borrower and therefore avoid foreclosure. Modifications are generally considered only when the borrower is already missing payments but still has some financial security and hasn't filed for bankruptcy. Loss of a job may also be a reason to initiate a loan modification. Loan modifications can be made to the payment, such as capping the monthly payment based on a percentage of the borrower's current income, the interest rate, or to due dates. The amortization schedule can also be extended so that the monthly payments are reduced. The principal remaining on the loan will almost always stay the same, although there are some situations where the lender will agree to reduce the outstanding principal. The modification for a particular borrower may use only one of these alterations, or a combination of them. The modification is made through a document called a loan modification agreement, which spells out the new terms of repayment. This agreement amends the original security agreement and note, but doesn't replace it. Any of the original terms that aren't explicitly changed in the loan modification agreement remain in effect. The loan modification agreement is signed, notarized, and recorded. Potential problems with loan modifications. Problems with loan modifications can be experienced by both the borrower and the lender. Problems that borrowers may experience when requesting a loan modification are usually the result of mistakes on the part of the mortgage servicer that processes the application. These include failing to process the application in a timely manner, giving the borrower incorrect information about the process, asking for a down payment, which is not required to get a loan modification, incorrectly calculating the effect of loan modification versus foreclosure in terms of the investment's value, and therefore refusing the loan modification. The lender will also want to avoid possible issues. For example, a loan modification may affect lien priority. The mortgagee will usually require a title examination to ensure there isn't another lien that could take priority when the loan is modified. Assumption and subject to. The alienation clause in a security instrument makes it clear that the collateral property can't be sold or transferred without the lender's knowledge and consent. If the borrower does transfer the property without obtaining the lender's consent first, this clause allows the lender to make the loan immediately due and payable. This is called acceleration. That's why the alienation clause is also known as the due on sale clause. However, there are ways to transfer a property, even if the alienation clause is present, without the lender accelerating the loan. Assumption. With or without an alienation clause, a buyer may ask to assume a loan. Why? Well, when interest rates are low, there's no real advantage to doing so. But at times when interest rates are high, and the seller has an existing loan that was originated when interest rates were low, a buyer may be eager to assume such a loan. At the same time, a lender would really like to have the buyer get a new loan at the higher market interest rates, and would be hoping that the original security instrument included that alienation clause, which would allow the lender to refuse the assumption. But if the alienation clause isn't in the original instrument, or if it is and the lender agrees to an assumption, the buyer can assume the original loan with all its original conditions. In this case, both the original borrower and the new borrower are liable for the loan's payment. If the new borrower defaults on the loan, the lender can foreclose, sell the property, and ask for a deficiency judgment from the new borrower if the proceeds from the sale don't pay off the loan. If the lender still doesn't get the money it's owed, the original borrower can still be sued for that money. If more than one assumption occurs on a particular loan, then all the borrowers are liable when a default occurs. There are a few situations where the lender can't enforce an alienation clause. The Federal Garnistee Germain Depository Institutions Act of 1982 prohibits the enforcement of an alienation clause when the property is being transferred between a parent and a child, to a relative as a result of the borrower's death, between spouses, or as a result of a divorce. A lender is more likely to agree to an assumption in these situations, if the buyer wishes to assume the loan. An assumption is officially documented with an assumption agreement signed by the buyer and the seller, which stipulates that buyer will be taking over payments for the note held by the lender. An assumption will usually require that the new borrower meet the lender's qualification standards. In some cases, the lender may even alter the terms of the loan when it's assumed, and there may also be an assumption fee to pay. Benefits to seller. One benefit to the seller with an assumed loan is that, in a slow market or when mortgage money is tight, a loan assumption might make the difference between selling the house or not. A buyer with enough cash to pay the difference between the existing loan balance and the negotiated sales price may still not be able to get a mortgage, provided the buyer can demonstrate adequate creditworthiness to the seller. An assumption may make the sale. Detriments to buyer. As with any real estate transaction, a loan assumption may have many pitfalls. It's important that buyers and sellers seek legal advice to ensure that everyone is protected. Buyers still face loan qualification by the lender in order to assume a loan. A hefty chunk of cash might be required as a down payment in order to cover the gap between the existing mortgage amount and the negotiated sales price. This may mean that the buyer's investing a good deal more cash in an assumed transaction than would be required for a new loan. Buyers will usually pay a loan transfer fee, which will offset some of the savings gained from paying no loan origination fee. Subject to. In certain situations, a buyer may not want to assume a loan, but instead will buy the property subject to the existing financing. The buyer gets the deed to the property, but rather than assume the loan with the lender's consent, the new buyer makes the payments on the seller's loan as if nothing has changed. Why would sellers let someone else take responsibility for a loan in their name? Investors buying a property that's at risk of foreclosure may find that a seller is more than willing to take this risk. The seller is already in a poor situation and is about to lose the property. As long as the new buyer makes the loan payments on time, the seller's credit score won't suffer, and the risk of foreclosure is removed. This may sound a little dodgy, but it's legal, assuming that there isn't an alienation clause in the security instrument. Typically, a lender won't care who makes the payments, as long as the loan's being paid. If the lender does become aware that titles transferred in someone other than the original borrower is paying on the loan, it may not be worth it to the lender to pursue the matter as long as the loan continues to be paid. A lender will prefer to have a performing asset rather than spend time and money to accelerate the loan, which may also result in the lender having to foreclose. Release of liability and novation. Whether a buyer assumes a loan or makes the purchase subject to the existing financing, the original borrower remains liable until the loan is paid off. With an assumption, that liability can be removed by requesting a release of liability or a novation. Release of liability is simply a written agreement that the lender won't hold the original borrower liable for the loan in case of default. A novation is a little different. It's a process that replaces the original borrower with the new borrower as the maker of the note. Obviously, replacing the responsible party would have to be done with the lender's consent and cooperation, so novation isn't a part of a purchase that's made subject to existing financing.